Full stop. Subsequently, the said divisional manager wrote to the certificate officer that the demand would be rupees 17,035.50. Inviting the court's attention to a letter written by the certificate officer to the divisional manager bearing memo number 600/CERT/HOW dated September 8, 2023. It is submitted that the certificate officer is unable to proceed with the certificate proceedings in view of the indecision of the divisional manager as to the exact amount recoverable from the petitioner. Full stop. The petitioner submits that the petitioner has made a representation before the certificate officer on January 10, 2024.
Copy to divisional manager,
thereby seeking direction upon the divisional forest officer to refund a sum of rupees 69,809 to the petitioner. Full stop. Insofar as the prayer for refund of a sum of rupees 69,809 is concerned, the same cannot be entertained by a writ court because in directing the same, the writ court would have to assess the factual matrix of the case, which involves claims and counterclaims of the contesting parties. Full stop. There is evidently a certificate proceeding which shows that amounts are due and recoverable, which shows that there are allegations of the amount lying due and recoverable by the forest department from the writ petitioner. Full stop. In such view of the matter, justice would be subserved if a direction is passed on the certificate officer to conclude the certificate proceedings as expeditiously as possible. Full stop. With the aforesaid directions, the writ petition is disposed of.
Only one innocuous prayer. My lord has held that the amounts of due and recoverable for the
Allegedly.
Because my lord, the certificate of
allegedly. I've said allegedly.
Because you have said that kindly inform whether if at all.
Said because there are counterclaims. You say something is due, they say something is due. How will the writ court decide?
One thing only, my lord, since affidavits has not been called for, all allegations that
the learned advocate appearing for the state
for the
disputes the claim of the petitioner. Full stop. Since affidavits have not been invited.
For the Forest Corporation also, I am also disputing.
Appearing for the respondents, dispute the claim of the petitioner. and say that disputed questions of facts are involved. Full stop. They pray for dismissal of the writ petition. Satisfied? Since affidavits have not been invited, the allegations made in the writ petition will be deemed not to have been admitted by the respondents.
Grateful.
The instructions submitted by the state respondents will be kept with the records.
Grateful.
Grateful, my lord. Grateful.
Passed over. Not today. Passed over.
35, I'm appearing for the state.
Petitioner.
For the petitioner.
Lordship, 35, I am for the Rajput municipality, Lordship. 35, I am for the Rajput municipality.
কি শোনা যাচ্ছে? শোনা যাচ্ছে।
Well, I am appearing for the mobile tower company in item number 35.
I am appearing on behalf of the Telecom Regulatory Authority.
Well,
That is not a necessary party in this dispute.
Well, the writ petition alleges, my lord, illegal erection of the mobile tower, my lord. Ours is a fully compliant site, my lord. The permission is there, my lord. Everything is there. My lord, the permission, I can hand up the copy of the permission. In respect of
Let me hear the writ petition.
my lord.
Lord, my contention is that the mobile tower that they have erected, they have not obtained the necessary no objection that is required as per the guidelines given by the West Bengal state. I will state that in paragraph number 14.
Who is the authority who is supposed to take a call?
Lord, I made a representation before the telecom authority. They respond by representation dated 15th May 2024. They responded that they do not deal with they are not in allocating or renting the premises for establishment of the mobile towers. They asked me to approach the Department of Telecom. I made them the party. My only representation which I made before the Telecom Authority, my lord, that may be considered by the Department of Telecom and be decided by after giving opportunity of hearing to both the parties.
Possibly already Department of Telecom अपनी appear कर चुकी है। वही यार की। My lord, there is a policy, although I am not.
My lord, may I hand up a copy of the policy, my lord?
There is a
Yes.
आपके policy.
Yes.
अच्छा।
Let me just see who is appearing for whom. First of all,
there is a नতুनটা।
state who is appearing.
Lord, I am appearing for this.
You are appearing
District
to the
level
state.
Right.
Well, this certificate is to be given at a district level.
My lord, the matter has to be
If
referred to the
telecom
district manager,
department-
my lord, magistrate. My lord, this is the comprehensive guideline, my lord, which is governing the subject matter, my lord. My lord, in any event, my lord, the municipality has no role. My lord, everything has to be taken into account, my lord. All the grievances to be laid before the, my lord, district magistrate under this, my lord, guideline. My lord, this is a single window guideline, my lord, guiding the installation of mobile tower in the state of West Bengal.
One. Where is the provision where it has been said that the district magistrate is the proper authority?
My lord, appropriate authority, my lord, your lordship find 4 and 6, my lord. 6 is the provision, 6 is the application for NOC, and my lord, thereafter the grievances. Disposal of application, single state level authority.
State
my lord,
level
seven.
authority ওগুলো কোথায় আছে দেখো।
7.
Okay, can I have the copy of the regulation? Can I have the copy of the regulation, my lord?
Yes. Please give him a copy, the regulations.
There have been various order passed
And-
by Lady Justice Amrita Sinha in this matter. Those judgments, those matters have been dealt in that case. If the advocate for the petitioner would.
Bring those orders.
First of all, the sanction plan from the Rajput municipality is required. They have not obtained.
Lord, that is not for the purpose
No,
of
no,
the
no.
installation of
Why
mobile
that
tower.
that is
Lordship, I
required,
have
Lordship.
already
That
handed
is
over,
a
my lord, copy of the, my
that is
lord.
judgment of
the no objection
Justice Mantha,
certificate.
Lordship. I will produce, Lordship.
Let them produce, my lord. My lord,
Lordship, there is they have to obtain sanction plan. Otherwise, building is illegal. How they will sanction the
Bring the judgments of Justice Sinha and Justice Mantha.
Lordship,
When do I keep it?
my lord.
next week, Lordship.
Next week,
In the first week of April, Lordship, in the meantime, Eid, Lordship.
Friday.
I cannot fixing next week of April. My determination is only till 28th. If not today, then not today.
Lordship, fix the short order, Lordship, 28, Lordship.
28,
Lordship. Lordship, pass and short order, Lordship.
लिखे
But is there a requirement for the state to file a report?
file report, everybody can file.
States করলেই তো হয়ে যাবে তোমার কাছে আছে regulations have. I think if state files the report, it will suffice because
Clear report.
they are aware of all the regulations.
लिखे in fact.
We don't have any allegation against us.
Where is the affidavit of service?
The affidavit of service, the only problem is that the track report, some of the track report is missing. So I'll be needing time, 2 days time to bring the missing track.
Come with the affidavit of service.
I can come on Friday, my lord.
Pass and short order, Lordship.
No,
Otherwise,
let him come with the affidavit of service.
But
Lordship. Otherwise, our
My
purpose,
service is not complete.
Lordship, pass and short order.
everybody is appearing.
Fixing the date, Lordship, along with service.
All the
your
parties are
service,
appearing, my lord.
No, no. Without affidavit of service, I'll not.
My lord, I will bring.
Even if parties are.
Okay, man. I'll bring. Grateful. I will bring.
Will you be able to get it tomorrow?
My
Kindly keeps it on.
Friday, I'll bring it.
28th. So bring all the judgments also so that it is complete.
36.
Oh, grateful.
Service.
But I served the copy of the writ petition upon all the parties. This is my affidavit of service. So far, respondent number 3, my lord, has come back with postal endorsement in sufficient address. Others have been served. 1 and 2 has been served, and the state has also been served, but today none is appearing. My lord, my prayer in this writ petition is, my lord, quashing of the proceeding initiated under
No,
the
but
maintenance
Mr.
and welfare of parents and senior
Mr.
citizens.
Mahato, but respondent number 3 will be affected.
Yes. Reason is
To be served.
my lord, why it has come back with postal endorsement, I do not know, because my lord, they filed a.
Washing is something I cannot take in his
Yes,
absence.
that's true. I am not praying for my lord that it should be hard expertise. I should not. My lord, in that event, my lord, kindly allow me to
Serve
file.
again. Serve. लिखे in order लिखे. Affidavit of service filed today is kept on record. It appears from the affidavit of service that the respondent number 3 has, in as much as the postal article has returned unserved with the endorsement with an inverted comma, wanting father's name of the addressee, insufficient address, comma closed. Full stop. Since any order passed in the instant proceeding would have effect on the respondent number 3 who is still unserved, this court feels that a copy of the petition should be served upon the respondent number 3. Full stop. The petitioners are directed to effect proper service upon the respondent number 3 within a week from date. Full stop. The matter shall appear in the list. Now, the petitioners will have liberty to mention the matter once service is complete.
My lord, may I pray one thing? My lord? The respondent number 3 has filed a suit. That suit is pending. May I serve upon the learned advocate? In addition to that,
Since it appears from the material on record,
my lord, page 4, paragraph 10.
that the respondent number 3 has instituted title suit number 383 of 2024 before which court?
It is, my lord. My lord, I have annexed the
For
plain.
the Court of Civil Judge, junior within bracket Junior Division at Midnapur Sadar, the petitioners will have liberty to serve a copy of the writ petition upon the learned advocate representing the respondent number 3 within brackets plaintiff in the suit in the trial court. In addition to the service as directed above.
I'm good.
The petitioner will have liberty to mention upon completion of service.
Opposing on behalf of respondents 2 and 3.
Appearing for?
Opposing on behalf of respondents 2 and 3.
As filing the service certificate of service. My lord,
Yes, sir. What are you
Yes,
challenging?
my lord, I am the petitioner in this case. I am this is a matter of bank guarantee. I am a guarantor. Not only I am borrower, not chief borrower, I am not, but my property has been attached. And the borrower has been roaming on various states in India. But bank authority did not take any step to catch him. They did not inform to the police authority, CID authority, not anybody. She has flagged up rupees 29 lakhs and paid off. He did not pay money. And bank authority also took my possession, and we are roaming with my family in the street. They also catch my all articles, household articles they have taken.
What is the subject matter?
Among they have also on the last date before their learned tribunal, bank tribunal, second to their learned advocate on their last date to submit it, then we shall inform her. Yes, we have not informed the police authority. In this time, we shall also inform the police authority.
What is the subject matter of challenge here? What are you challenging here?
Challenge here without any authority, without any information, my property has been attached. My property, I have
some order has been passed.
No. This is a surprising matter. The learned advocate of in the tribunal, she also submitting the matter is going on. There was settlement on various dates.
No, I see.
Annexed P1, P2, page number 20, 21. Learned bank's advocate is submitting. The matter is going on for settlement. On the other hand, 1623, they have also attached my property. And on the same date, learned advocate in the bank tribunal saying that the matter is going on for settlement.
The bank has taken physical possession of the property under section 13(4). The remedy is before the DRT. How it is maintainable?
No, bank's advocate also permitting before the tribunal, the settlement process is going with the chief borrower. But I am not the borrower. Settlement processing is going on with the chief borrower, my lord.
The borrower and the guarantor in terms of the SARFAESI Act and the DRT Act. Please go through the Act. Even otherwise, under the Contract Act, the liability of a borrower and a guarantor are coextensive. So it is the bank's choice. They can proceed only against the guarantor. They can proceed only against the borrower. They can proceed against both.
The bank authority did not take any action. The chief borrower has been paid here from India or state. They have not taken any steps.
They may not take. You are the guarantor. You are enough. If they get hold of you, they will get it from you only. Not a problem.
They have taken my agricultural land, my lord. They have taken my agricultural land. I have
that is to be decided by
small
the
poultry farm
DRT.
on that land.
They have taken
my poultry farm.
No, this writ is not maintainable.
But kindly appreciate one aspect. The writ petition should be dismissed at the threshold. Why I am saying so? This is an abuse of the process of the court, process of law. Lordship, the borrower has suppressed the fact. The writ petitioner has suppressed before this honorable court with regard to filing of SARFAESI application under section 17 of the Act, which is being the essay number is 534 of 2022, which is pending before the learned Debt Regulatory Tribunal 2, Kolkata.
Where the same thing has been challenged.
Yes,
Have a copy.
Lordship, I would may I kindly allow me to read out the last order passed by the learned presiding officer on 4th of October 2024. I'm handing over the hard copy to Lordship's officer in course of the day. Submission has been made on with the applicant that the auction purchaser has been added as a party and applicant shall be issuing notice. List the case on 10th of January 2025. On that particular day,
And his property has been sold.
yes. And the auction
on
purchaser
the-
has been included as a party respondent.
2005 learned banks
When was the
advocate is submitting before the tribunal
I
that
find-
we are doing state to police authority. Why
The
chief
counsel,
borrower?
please see page 37. Please see page 37 of your writ petition. When was it sold? On 16th of December 2022.
Yes. 16 December.
When? Because there are so many sale notices. There is another one at page 38, 10th of January 2023.
10 January 23.
When
Sold,
was it
sold,
sold? Because you are
sold.
saying yes to both.
Sold out. And Pachnama has been
When was it
I-
sold, Mr. Rai?
Lordship, exact date of sale I cannot
23.
apply to Lordship right now.
23.
No, the sale notice can enclose currently.
There are two sale notices
Yes.
in respect of the same property.
No sell.
If your Lordship kindly pass it over for 5 minutes, I can take instructions from my client.
Passed over.
I'm
for 5
grateful.
No
minutes.
sell notice.
Passed over. এটা থাক।
This matter I am for the petition of my.
Yes.
I appeal for the status. The petitioner herein made a representation before the additional district sub-registrar for supply the certificate copy of a particular deed which was registered in the year 1990. But the deed was written by the respondent because during that period, huge numbers of stamp paper found forged. Therefore, criminal case also pending. But until unless supply that deed, I am not able to mutate my name before the concerned block land records officer. Similar footing, one order has been passed, my Lord Justice Bossas, my Lord, kindly see for a moment.
Your representation is pending.
Yes.
They have a copy of this order.
You are appearing for whom, sir?
I am appearing for the status one.
All the respondents.
All the respondents.
Why are you not disposing of the representation? Take a decision on that.
I got a report from the ADSR, that is Additional District Sub-Registrar. He says that including this deed, a huge number of deeds that are seized and is in the custody of the police station, local police station. They are holding all these deeds. So the ADSR is not in position to give me the deed and the copy of the deed. Moreover, this FIR was lodged in 1991. It is in the knowledge of the petitioner. That is not taken in the petitioner.
No, that was not lodged by the petitioner. The previous landowner.
Even
Where is the report? Kindly show me the report.
কোন হবে?
ওই বসাকের order.
একটা আছে দেখেন।
Serial number 106 one. It appears that 183 deeds are seized. So ADSR's office is not having this.
It is with the police. That is what the report says.
The policeman.
The deed is with the police and it says that this deed is included in the fourth stamp case.
Yes,
Your
sir.
deed is included in the fourth stamp case. So
Yes,
how
yes.
can you get it now?
But only certified copy, my lord, not
For,
original.
for getting the certified copy, you need to have the original. It is from there only that the photo state copy will be made or a copy will be made and it will be certified.
And order, my lord, kindly see for it.
There the situation was different. There it was not with the police. It is with the police. Here it was not with the police. In the order that you have just now placed, see, the deed was retained with the registry. Here it is not with the registry. It is with the police. And the case was it may be forged. Here it says it is involved. There is a difference. Kindly see the order. Kindly see the last paragraph of the order at the first page. The learned advocate appearing for the state submits that the deed was retained on the ground that stamp paper used may be forged. He submits that there is a criminal proceeding pending.
This order.
This order should not prejudice such criminal. This was in 2021. And see now in the instruction that has been given to me, handed over to me, it has been written that we would like to intimate you the fact that the required deed is addressed to the learned advocate appearing for the states. This deed is included in the fourth stamp case seized by Patashpur police station under FIR such and such. Your deed is seized by the police. It is lying with the police.
Subject to the correction, my lord, kindly direct the police authority to supply the photocopy of that deed.
And the police authority, they are not made party here. Another allegation of the petitioner is that the original owner, they are occupying and they are disturbing the peaceful.
No,
position of
original
the
owner
petitioner.
was Abdul Hakim sold the property in the year 92, Kanaila Ladok, subsequent we have subsequent purchaser.
Cannot pass this order on this writ petition.
And they are also not made party. They ought to have been made party.
But it is admitted
As
that they
private
have
respondent.
written by the respondent and seized.
The writ petitioner is aggrieved by non-supply of the certified copy of deed number 2550/1990 to the petitioner by the respondent
General district service.
Established.
number 3.
Four.
Number four.
Number 4.
Respondent number 4. Full stop. The learned advocate appearing for the petitioner submits that the respondent has has not acceded to the request of the petitioner for supplying certified copy of the deed in question, of the subject deed, on the ground that a criminal proceeding is pending and that a representation made by the petitioner on September 24, 2024, addressed to the respondent number 3, is still pending consideration. Full stop. The learned advocate, he further submits that in similar situations, this court had, by an order dated July 14, 2021, passed in WPA 1712 of 2020, directed the respondent registering authorities to issue certified copy of the deed presented for registration, subject to the petitioner paying the deficit stamp duty if there be any, with the observation that the said order would not prejudice the criminal proceeding that were pending or that may be initiated in respect of the stamp paper used. Full stop. The learned advocate appearing for the state hands over a copy of, I'm keeping it on record,
My lord.
a copy of the instructions issued to him by the respondent number 3, from where it appears that the subject deed, being deed number 1, Roman 1, I-2550 stroke 1990, is in the custody of Potashpur police station, as the said deed is, in inverted commas, included in the forged stamp case, inverted comma close, and has been seized by Potashpur police station under FIR number 76/91 dated 09/08/1991. In view of the aforesaid, the request of the petitioner for grant of certified copy cannot be said to be wrongly declined by the respondent number 3, full stop. If the petitioner's deed forms the subject itself forms the subject matter of a criminal proceeding, full stop, comma, it would be too early for this court to direct the respondents to supply a certified copy thereof to the petitioner. যেখানে too early লিখেছেন, it would be improper করে, full stop. Insofar as the order dated July 14, 2021 is concerned, it appears that in the said case, the deed was retained by the registering authority on the ground that stamp paper used could be forged. Such is not the situation here, as the deed is lying with the police authorities upon the same being seized. Full stop. In such view of the matter, no order can be passed on this writ petition. WPA such and such is therefore dismissed. No costs. And the copy of the instructions handed over to the court by the learned advocate appearing for the state is kept in the records. Affidavit of service to
Appear for the response.
39 is my petition, my lord. This is the affidavit of service. My lord, the petitioners are the freedom fighters before lordship. Association of Freedom Fighters. Association of Freedom Fighters The freedom fighter scheme was originally initiated in 1969, and it was meant only for the persons who were incarcerated at the Andaman jail. Subsequently, 25th anniversary came in 1972.
Policy decision has been challenged, my lord, with still existing since 2016. This cannot be decided without filing an appeal.
Right. There's no scope for.
I'm challenging the basis of changing the granting of dearness relief.
Very well. Then it has to be decided on affidavits. The stand has to
Yes,
come.
only the, because
And there's no scope for interim order in between.
no scope for interim order.
That is why instead of wasting our lordship.
Yes.
Only few freedom fighters are left surviving till now, lordship knows. If the affidavit can be granted.
Bhattacharya, you impinge upon him to file the affidavit within 1 week.
Yes, he will do it. I know my learned senior friend would do it.
Hmm. The writ petitioner or petitioners?
Association petition.
The writ petitioner association. The writ petitioner is an association of freedom fighters. Full stop. The writ petition has been filed laying challenge to, what is this, a notification?
This notification, lordship will get it at page 30, 30.
Laying challenge to
hard copy
a notification dated August 17, 2016. अच्छा, notification bearing number लिख देना, number 45//2016 capital F within brackets capital P, dated August 17, 2016, pertaining to enhancement of pension under the Swatantrata Sainik Samman Pension Scheme, 1980, in respect of freedom fighters and their eligible dependents. Enhancement থেকে eligible dependents of the inverted comma.
I am challenging at page 31 the clause 2.
अच्छा, lays challenge to যেখানে লিখেছেন একদম starting এ, this repetition laying challenge to clause 2 of the notification way, such and such. अच्छा, the petitioner submits that the dearness relief system based on All India Consumer Price Index for industrial workers was replaced by dearness allowance system applicable to central government employees twice a year.
Lordship. But the effect is less
By the said scheme
by the said.
or said scheme stroke notification. The petitioners are aggrieved by the substitution of the dearness allowance system applicable to central government employees twice in a year in place and stead of the existing dearness relief system,
Lordship.
the erstwhile dearness relief system based on All India Consumer Price Index for industrial workers. Mr. Bhattacharya, learned senior standing counsel for the respondent numbers,
All the rest.
for the respondents, submits that The notification was the result of a policy decision taken by the government of India. Full stop. And that the same is constitutionally valid. Full stop. Having heard the learned advocates for the respective parties and having considered the material on record, it appears that the issue involved herein cannot be decided without the respondents spelling out their stand on affidavits, in the facts and circumstances of the instant case. There is no scope for passing an interim order. Full stop. In view thereof, comma, the respondents shall be at liberty to file their affidavit in opposition within 4 weeks. 4 weeks.
It will, once drafted, it will.
6 weeks will be too long because, as he said, 4 weeks.
As such, there is no urgency in the matter. He will get the release.
No, if they die, then what will happen? Freedom fighters, 4 weeks. 4 weeks. Reply if any there to within
2 weeks.
2 weeks thereafter. Liberty to mention for hearing after completion of the time for exchange of affidavit.
I have not received the hard copy.
Please serve upon.
To buy today. My lord, the affidavit of service is.
Affidavit of service filed today we kept.
Obligement.
Passed over, madam.
Lordship, I have taken instruction. Past 37. Lordship,
না ঠিক আছে কোনো অসুবিধা নেই টুকু চলবে
Lordship, I have taken instructions from my client. The sale confirmation advice was issued on 8th of September 2023 in favor of Mr. Yunus Khan.
8 September
2023. And the bid amount was 15.10 lakh.
Auction
no
purchase
but
are-
it was auction sale of what 10th of January 2023 that notice.
No, on 6th of March 2023.
auction notice was not served upon me. I have also collected auction notice from Quantai Post Office on 14th February 2023 and 6 March 2023 auction proceeding was held.
Mr. Counsel, the
Auction proceeding was held without violating the rules.
Your remedy is not before the writ court. There are several decisions now, and writ is not maintainable. The
Lordship,
recent
kindly,
one-
Lordship, kindly allow me to place certain
They have
judgments
not
of the
taken
honorable
any step upon the chief borrower. I am the guarantor. They have also agreed step upon me.
That
They
is
have not touched the
point.
property of the chief borrower, but he has played away.
Lordship, kindly allow me
They
to
have not taken any step about him, informed before the police authority, CID authority, where he has gone.
Not required. If the guarantor is there, they will go against the guarantor. Borrower may not be there.
Also, no, Kintu.
They are on
So
the
this
equal
is my
footing.
only one residential house. They have taken my agricultural land.
mortgage-
They have taken my one small poultry. From that poultry, I am and
Should not have mortgaged
reviewed.
it then.
I-
You have your remedy. I'm not foreclosing your remedy. If you have your remedy, approach the DRT.
Lordship, Section 17 application is pending at the instance of my learned friend
You have filed a section 17.
since 2022.
Then-
Lordship, I am relying on certain judgments of the Apex Code reported in 2011. 2 Supreme Court cases, page number 782. That is Kanhaiya Lalchand Sahadev versus State of Maharashtra. Lordship, relevant paragraph is page 20, paragraph number 23. 2011, 2 Supreme Court cases 782. Lordship, kindly allow me to place another judgment passed in Devi Ishpat matter that is reported in 2014 5 SCC 762, paragraph numbers 8 and 9. And last judgment, kindly allow me to place 2022 5 SCC 345, that is Phoenix ARC Private Limited versus Vishwabharati Vidya Mandir and others. Lordship, relevant paragraph is paragraph number 21. The Honorable Apex Court has been pleased to hold that So when section 17 application is pending, filing of writ petition amounts to abuse of the process of law.
Yes, please take down.
They have taken house property as a street property deal, as like property dealer. But the respondent bank authority, they have done as a property dealer.
The writ petition has been filed seeking issuance of a writ of mandamus, commanding the bank. না ওটা না লিখে এইভাবে লিখুন। The writ petition assails the action of the bank under section 13(4) of the SARFAESI Act, 2002. Full stop. The learned advocate appearing for the learned advocate appearing for the writ petitioner submits that the bank has acted in a high-handed manner in taking physical possession of the writ petitioner's property and putting it on auction under SARFAESI Act, despite the fact that the writ petitioner is a guarantor and not the borrower. The writ petitioner complains that the bank has, for obvious reasons, failed to pursue its remedy against the principal borrower and has latched on to the property of the guarantor. Full stop. It has been further submitted that it is impermissible for the bank to take recourse to the remedy only against the guarantor while leaving the borrower scot-free. Full stop. It is therefore prayed that the property of the petitioner that has been attached and sold may be restored to the petitioner. The learned advocate, your submission is recorded. The learned advocate appearing for Mr. Rai, the learned advocate appearing for the respondent bank submits that the instant writ petition is not entertainable for more than one reasons. Full stop. He submits that challenging the action of the bank under section 13 within brackets 4 of the SARFAESI Act 2002, the writ petitioner has already approached the Debts Recovery Tribunal
Number 2, Kolkata.
Debts Recovery Tribunal number 2, Kolkata, by filing an application under section 17 of the said Act of 2002, being
SA number 534 of 2022.
SA 534 of 2022. Full stop. Relying on the judgments of the Honorable Supreme Court in Kanhaiyalal Lalchand Sachdev and others versus State of Maharashtra and others, reported at 2011, volume 2 SCC 782, para
23, Lord.
para 23. তারপরে Devi Ispat Limited and another versus State Bank of India and others, reported at 2014, 5 SCC 762 and Phoenix ARC, PHOENIX, Phoenix ARC Private Limited versus Vishwa Bharati Vidya Mandir and others, reported at 2022, 5 SCC 345 within brackets, comma para 21. It is submitted that that writ remedy is no longer available to the writ petitioner. Full stop. Laying emphasis on the observations of the Honorable Supreme Court in the case of Phoenix Supra, in paragraph 21 of in the case of Phoenix Supra, it has been submitted that the practice of approaching this court under Article 226 of the Constitution of India, after having approached the DRT under Section 17 of the SURFACE Act 2002, has been strongly deprecated by the Honorable Supreme Court. Full stop. Upon having heard the learned counsel appearing for the respective parties and upon perusing the material on record, this court feels that this writ petition is not fit to be entertained. Full stop. Authorities are legion on the point that if an efficacious and expeditious alternative remedy is available, writ petition should not ordinarily be entertained unless core jurisdictional issues or issues pertaining to violation of principles of natural justice or virus of an act are involved. In the case at hand, nothing of the aforesaid sort has been cited or even attempted to be shown to be involved. Full stop. The contention of the writ petitioner that the bank has proceeded only against the guarantor and not the borrower is equally without merit. Full stop. The provisions of the Contract Act make it amply clear that the liability of a guarantor is coextensive with that of the borrower or the principal debtor, and the creditor would be free to take recourse to any remedy available to it against any one of them, either singly or together. Full stop.
Lordship, I had also taken a point of suppression.
ওই যেখানে ওনার সাবমিশনটা রেকর্ড করেছেন মিস্টার রায়ের, he further submits that the writ petitioner is guilty of suppression of material facts in that the writ petitioner has not indicated to the court that he has already approached the DRT prior to the filing of this writ petition. Full stop. শেষে এবার চলে আসুন। Since the writ petitioner has already approached the DRT under Section 17 of the SURFACE Act, the present writ petition becomes all the more in the nature of an abuse of the process of law. Full stop. The writ petition is therefore dismissed. No costs.
I'm grateful, Lordship.
Mr. Rai, please hand up a copy of the order of the DRT
Yes,
to
yes.
show that it is pending.
Yes, definitely.
It is pending still, na?
Still now.
Please
Yes,
give
yes.
a status report also. I'll
Yes, yes, definitely. I'm
Total
adding on
लिखे
to
दिन
lordship's officer. In course of the-
एक to लिखे दिन may Mr. Rai hands over a copy of the order and the status report of the surface application. Please give a copy to your learned friend also.
My lord, with regard to item number 40, I am paying accommodation for 2 days. So on Thursday, let it be on Thursday.
Thursday.
My dear.
Thursday.
Lordship,
Appear for the state.
I'm for the petitioner before Lordship. Served upon all received it.
ढाबे तो 5 मीटर जो नहीं उड़ गए. Yes, sir.
Yes,
Everybody
Lordship.
has been served.
Yes, Lordship.
All the respondents.
Yes. Only private respondent number, only one is there.
He has been served.
He has been served.
What is the matter, sir?
The petitioners, the two petitioners, along with two others, they are the owner of 92.5 decimals of land. And out of the various plots of land which they purchased in the year 1982 by a registered deed of deed, I have annexed it as Annexure P1. The said land was purchased in the year 1982. And out of the said land, out of the various plots, one of the plot is plot number 3688. It is 3.77 decimals of land. Now, petitioners, Your Lordship, they, after obtaining a sanction plan, they made the construction work. Now, the private respondent and his wife, they lodged a complaint. They lodged a complaint that we have made illegal constructions, and that's even on their own land. So that the writ petition was filed, and wherein we appeared and we filed a sanction plan before this honorable court. There's an order to that effect also, but this honorable court found that there is something wrong with the sanction plan. The date and all are not there. This honorable court directed the petitioners, the private respondent out here, to make an application, go before the Pradhan and make an application, and to see whether the plan that is allegedly been relied upon by us, whether that is true, genuine, or a false one, and to proceed accordingly. Well, prior to Your Lordship, the private respondent had and 3-4 others, they filed a partition suit. A suit was filed. The suit was filed against 92 persons, including the petitioners. The suit is pending, and the suit was also in respect of one of these plot numbers, including plot number 3688.
What is your present grievance?
Yes, Lordship. Well, subsequently, Lordship, after suppressing the material fact, another application was filed by the private respondent before this honorable court, alleging that the petitioners has made constructions over PWD road. And this honorable court directed the concerned authority to look into the grievance of the respondent, as the petitioners out there, and allegedly found that I have made constructions over the land of the PWD. I was directed to remove the construction block from the front of the house of the private respondent and from the land of the PWD. That was, I had come before this honorable court. Well, this is my land. I have made constructions over my land, my property.
But
and
how
it
will
was,
the writ court decide this?
my lord, let them come forward as to how they have found out without making any measurement and nothing. They simply stated, Your Lordship, kindly come to the order, Your Lordship.
Yes. Page.
Yes, Lordship. Lord, at page 52.
52.
Proceedings of the hearing. Today's hearing, the petitioners and our learned advocate are found present at the time of hearing. The private respondents, respondent number 10, 11, and 12, are found present at the time. The petitioners of the writ petitioner
says that he is owner of the plots partly in questions, and the private respondents, being the encroacher, have raised unauthorized constructions by encroaching upon a portions of PWD land in front of her above mentioned plots, thereby they obstructing his ingress and egress. The respondent number 10 have constructed unauthorized structure by encroaching in front of both the plots. The respondent number 11 and 12 has constructed unauthorized structures in front of plot number 3688. As if, my lord, we are stranger to the plot number 3688. Jail number this, her sole grievance before this authority is to remove the encroachment as above from that of the land in questions belong to the department in accordance with law under the purview of West Bengal Highway Act. The private respondent also admitted that they have constructed unauthorized construction. This is a total wrong submission, Your Lordship. That's been recorded. My lord, kindly turn to page. My lord, this is the deed of 1982. My lord, 4 of the person, they're the 4 brothers. They purchased 92.5 decimals of land. And your lordship would be kind enough to take.
You were the private respondent in the earlier writ
The
petition.
earlier writ petition. My lord, kindly turn to page 18. My lord,
Page
18. This is the schedule of the said deed. My lord, it would be evident at the last, the 3 lines at the top. 3688. This is the plot number. At page 18.
Page 18.
Yes, lordship. The last but 3 line above. 3688. This is the plot in respect of the private respondent is claiming that he is the owner of the property. We purchased the property. This 3688. But subsequently, your lordship.
27 shatoks.
3688, 3.77 decimals.
3.77.
Yes.
3.7.
Yes. My lord, subsequently, your lordship, can we turn to page 22? The lands being recorded in our name.
22.
That number 3688 is there. The next page is also, it is recorded in my, in the name of this petition number 2. My lord, on the next page, your lordship, 24. This is the tax I have paid before the Pradhan, before the concerned Gram Panchayat. And the next page, your lordship, at page P3, it is the sanction plan is there. Can you take to page 26? Right hand corner, your lordship, the descriptions of the property is also given. Doug number 3688. So this is my land, your lordship. I have made constructions after obtaining sanction plan in my property.
And the civil suit.
Civil suit, your lordship. Next, your lordship, it was filed by the private respondent at page P4.
For the same grievance.
My lord, the petition, the plaintiff out there being the private, one of the private respondent out here, because he as the power of attorney holder of all the plaintiff.
You are the defendant there.
Yes, I was one of the defendant because there are 92 defendants are there.
What is the relief prayed for in the suit?
Kindly, your lordship, this is page 13. Nalishi Topshil Bonito Jomi Jamate Aknang Badir 49.637 শতক, 2 নং বাদীর 32 শতক, 3 থেকে 5 বাদীর গণের একত্রে 57 শতক এবং বকরি জমি বিবাদীগণের একত্রে শতাংশ থাকা সব্যস্ত পূর্বক বাটোয়ারা চিহ্নিত partition, and they are claiming the entire property. It's almost the entire property. And the suit, the property and the property that we purchased in the year 1982.
Where is the earlier order on the basis of which the assistant engineer has passed the order?
But the earlier order, your lordship, of page 42, your lordship, can you turn to 42? An application, your lordship, initially the private respondent filed before this honorable court, and this honorable court had specifically found, your lordship, can kindly come to next page 46. Certain questions was raised with regard to my sanction plan. So the last, at page 46, it is found that the plans were not genuine. The authority should take steps in accordance with sanction plan of the West Bengal Panchayat Act. Can you turn to the next page, Your Lordship? If it is found that the constructions were permitted in that event, the other remedies of the petitioners would be before the civil court. Only the point of deviation from the plan can be raised before the authority, and the authority shall then proceed in accordance with law. The entire exercise shall be completed within certain period. My lord, bypassing this, Your Lordship, he made a fresh application. Fresh application internally alleging that I have made constructions in encroaching upon the land of the PWD. My lord, then Your Lordship, this honorable.
In this writ petition 18542 of 2021, the allegation was that you have violated Panchayat
Yes.
provisions of the Panchayat.
Yes, Your Lordship. I have made constructions without any sanction plan. I came before this honorable court. I produced the sanction plan. There is some anomaly. The petitioner was directed to move before the concerned authority and make an application out there. If and the concerned authority to decide to see whether the plan was genuine or not. Well, thereafter, Your Lordship, can you turn to page 48? Annex P6. He made a fresh applications, and on the basis of which a fresh application was filed. Herein, Your Lordship, yes, Your Lordship. And then the respondent has proceeded as if I have made construction with encroach into the land of the PWD. When I have my own land, I have made constructions in my own property.
After this order was passed on 22nd of August 2024, did you write to the authority saying that you have wrongly written that I have admitted?
No, I filed this application immediately thereafter.
No, but law is otherwise.
Yes.
Anyways, let me hear.
Yes, yes, Lordship.
Yes.
My lord, kindly sees your lordship their conduct, my lord. When the first writ petition had been filed, now he is saying that bypassing the order of the earlier writ petition, he had made of next application, another writ application.
No, but the first writ petition was filed not by him.
The first writ petition had been filed by Kanchan Mondal, the private respondent herein. His prayer was that he was making a construction in violation of the sanctioned plan. That had been already, my lord, entertained by the honorable court, and an order had been passed.
Right.
Now, according to him, bypassing that order passed by the honorable court, he made a fresh application he made another application before this honorable court, which is registered as WPA number 15059 of 2024.
There the allegation was that he has
the allegation is that regarding the unauthorized construction.
On PWD land.
On PWD land.
There is
exactly,
a difference.
my lord.
There is a difference. In the first writ
Yes,
petition,
there is
the
a difference
allegation is
between
that
the first writ
his
petition and the
construction
second
may
writ
be on his
petition.
own land, but it is
Yes.
without sanction.
Yes, yes.
The second writ petition is that his construction is on a land which he does not own.
His construction is on a land which he does not own, and because of that construction, his ingress and egress have been obstructed.
Mr. Bose, how do you justify this order? Because this order does not speak about
This is what I am trying to say, my lord. When the second writ petition had been filed, he did not point out before the honorable court that he had already filed another writ application making certain prayers which had already been entertained. Bypassing that, he had filed another writ application.
But the second writ petition was also not filed by him.
No, I didn't file. Private respondent has filed.
The second writ petition had been filed by the first writ petition had been filed by the private respondent.
Second also by the
second also by the private respondent. Now his allegation is this: in the first writ petition, his prayer is that the sanction plan had been violated. Now the honorable court had passed certain orders raising doubt about the sanction plan. Now bypassing that, he had filed another writ application. Now, when the second writ application had been filed, that had not been pointed out by him to this honorable court, that the second writ application had been filed by Kanchan Mondal by bypassing the orders of the first writ application. He, my lord, accepted the order passed by the honorable court in the second writ application, and he appeared before the hearing authority. And before the hearing authority transpires from the order that he had admitted about the unauthorized construction. He said that he had made an unauthorized construction on the PWD land, but that is not obstructing the ingress and egress.
He's saying he has not made any admission.
My lord, where is that averment in the writ petition, my lord? He did not make any explanation in the writ petition stating why he has admitted before the hearing authority about the admission. There is no such averment. Now the hearing authority clearly records that he has admitted, but the only thing is that he is saying, I have constructed, but that is not obstructing the ingress and egress of the path of the private respondent. So this writ petition, my lord, at the threshold
This
is
is
barred by waiver and estoppel.
This is the application we have filed at the time of hearing before the authority. While we are being
There
called,
is no
we are being,
explanation.
while we are being called for
My-
hearing, we submitted this.
My
That,
respectful
that application,
submission before your lordship is this.
that this
There is no
application, we have,
explanation.
we
There
have-
is no explanation in this writ petition.
that we have filed, that you have filed this application, as you are proceeding with the demolitions of my structure, we filed this, made this representation. And at the last line, your lordship, it will be evident that we have pointed out about this application 2740 of 2024.
Your lordship knows, my lord, if any quasi judicial authority makes any wrong statement, it is the duty of the victim to bring to the notice of that quasi judicial authority that you had made a wrong statement. I did not make this admission. Nothing has been done. No statement had been made in the writ petition as to why he has admitted, or the quasi judicial authority, hearing authority had made a wrong statement by saying that I have made the admission. So this writ petition, my lord, is barred by waiver and estoppel.
When did you file this?
The date is there.
18th, or why did you not annex it to the writ petition?
Which is subsequently. That is
After
the,
filing of the writ
yes,
petition?
yes. We had stated that this application is pending. We have filed before this honorable court and it is pending.
Give a copy of this to your learned friend also.
I will.
My lord, I have not, my lord, received any copy of any application, my lord.
I haven't filed anything. It's this only writ application I have filed.
If you have not made any admission, and if this application has been filed before the authority, let the authority consider this application also.
Lordship, let him consider.
Definitely.
Give me a copy of the application.
I will.
My lord, I had obtained a copy of the police report. That is not helping, my lord, though. They are saying that we shall take steps according to the order of the authority. Anyway, since I have received, my lord, kindly.
Well, I'll take it.
And furthermore, your lordship, at paragraph 10 of my application, we had specifically stated that no such avowals being made before the authority with regard to the unauthorized construction. Your petitioners state that at no point of time it was admitted by them on their behalf or that construction is being made in a part of the land of the government as has been alleged in the proceedings of the hearing. It's been dealt with. It's not that what my learned friend is saying that we haven't dealt with.
Very good.
Yes.
How have we served the private respondent? Kindly show it from your affidavit of service.
I will not touch it. Lord pending.
Affidavit of service filed today be kept with the records. The writ petitioner is aggrieved by the order dated. Writ petitioners are aggrieved by the order dated August 22, 2024, passed by the assistant engineer, Lokkikantapur Highway Subdivision, P.W. Roads within brackets, Directorate, wherein it has been recorded that the writ petitioners, within brackets, private respondents in WPA number 15059 of 2024, bracket closed, admitted that they had
Mark it up.
constructed unauthorized structures on PWD land in front of the plots mentioned in the said order. Full stop. And the learned advocate appearing for the writ petitioner submits that such recording by the respondent number 6 was absolutely wrong and incorrect, inasmuch as no such admission was made by the writ petitioners during the hearing. Full stop. The learned advocate for the writ petitioner places reliance on the schedule to what is this document at
It's a
connection
stale
P1?
deed. It's a deed of purchase. They purchased petitioners, Your Lordship, along with their petitioner number one's other two brothers. They purchased the property.
The deed of conveyance
92.5 decimals of land, which includes plot
Schedule of-
number
of
3680.
property mentioned in the deed of conveyance, whereby the petitioners along with their brothers
Petitioner
purchased.
number one's two brothers, other two brothers.
There are two petitioners.
My lord, the petitioner number 2 is the son of one Mahadev Bandal,
Okay.
the brother of
Petitioner
Basudev
number
Bandal.
1 along with his brothers had purchased certain properties which included
Plot number 3680.
3.77 decimals in plot number 3688.
Yes.
Full stop. He also places reliance on the record of rights, where plot number 3688, where 3.77 decimals in plot 3688 has been recorded in the name of the writ petitioner number 1. Full stop. He further places reliance on the what is this document at page 24? Ajna?
Panchayat revenue. Rent to paid to the Panchayat, Gram Panchayat.
To the rent receipt, evincing rent paid to the panchayat. But how do you get the plot number here? You don't get that.
No. It could be that while obtaining the sanction plan, this
So why did you rely on this? You relied on this, no?
Yes, this one subsequent pages is also there. Because I obtained the sanction plan, because prior to obtaining the sanction plan, you have to make an application, payment of the cost to be made.
Relies on the rent receipts at pages 24 and 25 of the writ petition to show that he had been paying rent to the relevant Gram Panchayat. Full stop. Reliance is further placed on the map.
This is a sanction plan.
On the sanction plan at page 26 of the writ petition to demonstrate that the construction was done upon the plan being sanctioned, duly sanctioned by the Gram Panchayat.
That is even in the suit plot 3680.
The learned advocate for the writ petitioner takes the court through the prayers made in title suit number 558 of 2019 instituted before the learned civil judge, first court, civil judge senior division, first court at Baruipur, where from it would appear that a prayer for partition has been made and the property, which is the property being plot number 3688, na?
Yes, Lordship.
Where is that in the suit?
My Lord, at page 41,
Page 41, yes.
in the middle of it, left-hand side, is the 3688.
কি লিখলেন শেষের লাইনটা পড়লেই হবে। (3688) is involved therein. Full stop. Placing reliance on the aforesaid documents, it is submitted by the writ petitioner that when there are wholesome documents to support that the land under possession of the property under possession of the petitioner is the petitioner's own property over which it has raised constructions. There could be no question of the petitioner making any admission, petitioners making any admission that they had constructed over PWD land. Full stop. The petitioner further hands over a copy of an affidavit sworn and filed by the petitioner before the subdivisional officer at Baruipur. In what connection was this affidavit filed?
This, my Lord, they were threatening us, my Lord, because the last order was there, I was asked to remove the structure in that connection, Your Lordship.
My lord, subsequently, my lord, after the order, there was another letter, my lord, on 27th of August 2024, subsequent to the order, where, my lord, he had been asked to remove the structures. It is annexed at page 55, annexure P9.
Yes, yes. Okay. কি লিখলেন? Before the subdivisional officer at Baruipur, whereby the writ petitioner number 1 করবেন এটা, writ petitioner number 1 has sought to put it across that there was never any admission made on the part of the petitioners that they had raised constructions over PWD land. Having submitted as above, the writ petitioner seeks intervention of this court in annulling annulling the order dated August 28, 2024, as also the subsequent notice dated
27th of August, my lord.
August 27,
Two orders,
2024.
22.8 and 27.8.
August 27,
That is the notice,
2024.
my lord.
Yes, calling upon the writ petitioner to remove the encroachment and restore the highways. Mr. Such and such, learned advocate appearing for the state, opposes the writ petition and submits that the petitioner, having admitted before the authority concerned, i.e. the assistant engineer, that he had raised constructions on the PWD land, cannot be heard taking a contrary stand today in court. Full stop. It is submitted that the petitioner has waived his right to challenge the said order passed by the assistant engineer, inasmuch as the petitioner has not approached the said authority by way of any application stating that his submission has been wrongly recorded, or that the petitioners did not make any such submission. Full stop. Mr. Such and such also hands up a copy of the report by the SI of বকুলতলা PS. Full stop. আচ্ছা, এই যে অ্যাপ্লিকেশনটা যেটা লিখলেন একদম স্টার্টিং এ petitioner hands up an affidavit বললেন, he has filed an affidavit. The affidavit is taken on record. Affidavit, have you served a copy of the affidavit on Mr. Bose?
My lord, that's the only copy I had. I will be serving.
Please
I'll
serve
be
it upon.
Yes, I will.
Course.
I will.
Having heard the learned advocates for the respective parties and having considered the material on record, this court finds that there is prima facie that it is prima facie doubtful that the petitioners would have admitted before the respondent number 6 in the hearing taken by the said respondent that they had raised unauthorized constructions on PWD land. In view of the plethora of documents placed before this court and the affidavit filed before the subdivisional officer at Baripur, a copy whereof has been handed up to the court. It would be proper for the respondent number 6 to revisit the matter and take appropriate decision upon hearing the parties once again. Full stop. The respondent number 6 would be free to affirm, modify, or annul his conclusion recorded in the order dated August 22, 2024, upon hearing the parties afresh. Full stop. The entire exercise will be completed by the respondent number 6 within a period of
my lord, 8 weeks, my lord. Subject to what your lordship thinks, my lord.
8 weeks.
8 weeks.
Within a period of 8 weeks. With this observation, the writ petition is disposed of.
My lord, your lordship will be kind enough to hand me over the copy of the affidavit.
Please hand it up.
I will, your lordship. I will.
Because I have recorded, I have taken it.
Yes, yes, lordship. Obliged, lordship.
I am deeply obliged.
Obliged, lordship.
I'll come back in 5 minutes.
Pursuant to lordship's direction, I have handed over to your lordship's office.
I'll be back in 5
Yes.
minutes.
I'm good.
না এই পরেরটাতে হবে না, 4টে ম্যাটার পরপর হচ্ছে এফিডেভিট সার্ভিস হয়নি। না 41 লাস্ট অব্দি গেল তো, হ্যাঁ 42, 43, 44, 45 এই 4টে ম্যাটারের হ্যাঁ দিতে হবে। 41 হয়ে গেল, এটাই 40। Number 42, 43, 44, and 45, these are the similar matters, Lordship.
Yes.
So we're praying for 2 weeks' time because affidavit of services has not been completed yet, Lordship.
Not this week.
2 weeks' time. Okay. Not this week, only give 2 weeks' time, Lordship.
Not this week means because my
Not this-
determination is only till Friday, so it will go back.
Okay, grateful, Lordship.
Forty-five. P6. And I am the petitioner. I have not affidavit services ready. I paying for not this week.
Not this week. Passed over.
I appeal for the
I am for the respondent. 9 and 10.
9 and 10 কে বাতিল করেছো কেন? না 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 9 10 রেসপন্ডেন্ট নেই তো আছে ও জেলা পরিষদ দাদা আমি ভাবছি প্রাইভেট মানে invoking section.
All the respondents are represented.
Yes, yes. Only Jila Parishad and the state. Well, 62 Act was invoked for removal of unauthorized encroachment over the government land. That has been done, removed. Ingress egress of my property is free. My lord, subsequently, in terms of the said act, government may settle the land on the basis of application of the applicant in accordance with law. I have made an application. Well, they are to consider my application in accordance with law. This is my prayer before your lordship.
Yes, Mr. Bari, any problem?
This application was made to the Jela Parishad.
No, the district magistrate is the authority. So, my lord, I find this application is not in form.
Then
It should,
withdraw and
or your lordship can grant me liberty to make an application before the district magistrate under the said act so that he can consider it. আমি বলে দিয়েছি দাদা আপনি DM is the authority.
collector.
Actually, the district collector, that is DM.
affidavit of service filed today be kept with the records.
দাদা হয়ে গেছে আপনি এসেছেন না সেই যথেষ্ট
The writ petitioner
আরে বেতন পেয়ে যাবেন চিন্তা করবেন
seeks issuance of a writ of mandamus commanding the respondents to grant long-term lease of a portion of government plot bearing number 194 in favor of
Deep.
Okay, nine.
My lord, this is my application.
Yes, on behalf of the state response, my lord, I'm saying which time to get the instruction from the department.
What is the matter?
My lord, this is my affidavit of service. My lord, matter is short. Let the petitioner, he participated, my lord, in a tender proceeding. My lord, the amount put to the tender was 77 lakhs. My lord, he, my lord, completed the work. There was a completion certificate. And my lord, subsequently, my lord, this tender amount, my lord, 6 lakhs of rupees out of 77 lakhs, that was not paid to the petitioner. My lord, during pendency of the work, another work order was issued by the respondent authority, requesting the petitioner, my lord, to do, my lord, some additional work. He did so. There is a post facto approval, but my lord, when the amounts come to 91 lakhs, then my lord, they remained silent, respondent authority. I moved an application before this honorable court, my lord. My lord, my lord, Shampa Sarkar was pleased to direct the respondent authority, my lord, to consider my case after giving an opportunity of hearing. My lord, that was done. My lord, in the reasoned order, they have stated that there is no financial approval. So, my lord, they are not in a position to pay the remaining portion of money. But the balance amount, 77 lakhs, my lord, they paid 71. That balance amount was paid to the petitioner. This is the actual position. Now, my lord, my respectful submission is this. Lordship, kindly have a look to the, my lord, the annexures. Page 17, my lord, is my work order that is issued, my lord, on 6th of March 2017.
Yes.
My lord, the amount put to the tender was 77 lakhs 311.17. My lord, out of this, my lord, I have already received, my lord, at that point of time, my lord, 71 lakhs. Now, my lord, Lordship, kindly have a look to page 25. My lord, this was, my lord, subsequently issued for, my lord, additional work. With due respect, I am to inform you that I am submitting herewith substitute supplementary tender related with the above mentioned tender for your kind approval and acceptance, please. That is page, my lord, annexure P3, page 25. Now, at the bottom portion, it was stated the MB number, that is the measurement book number, in which, my lord, my entire work was recorded. That was
1226.
Yes, 1226, page number 27 to 57. And, my lord, post facto approval was there, my lord. It was signed by the, my lord, executive engineer, special engineer, all. My lord, thereafter, my lord, they didn't pay. My lord, I moved this application before this honorable court, my lord. Lordship, kindly have a look to this, my lord, order passed by Honorable Justice Shampa Sarkar. My lord, that is page 39. My lord, may I place it? The writ petition is disposed of directing the Principal Secretary, Urban Development Municipal Affairs Department, Government of West Bengal, to dispose of the representation of the petitioner dated October 21, 2022 in accordance with law. If the authority finds that either partial payment or full payment as claimed in the said representation should be made, such payment shall be released within 3 months from the date of communication of this order. If the authorities are of the view that payment cannot be made to the petitioner, then reasons for not allowing such payment shall also be intimated within 3 months from the date of communication of this order. The question of delay shall not be a ground for rejecting of the claim. If the authority is satisfied that the claim is either fully or partially valid, the authority responsible for supervision of the work and the petitioner shall be heard. The order should be communicated within a week from such decision. My lord, I have communicated the order. Next page is annexure P8, page 41. My lord, here, my lord, a date was fixed for hearing. That was, my lord, 23rd August 2024 at 2:30 p.m. Now, my lord, the decision order was passed in page 43. My lord, relevant portion is this. Lordship, kindly have a look to this, page 45. My lord, clause 2, amount put to tender was 1 crore 8 8,08,971.33 only, and tendered amount was 77,311.17 only. The first and final bill against tender number such and such was submitted on 21st of February 2018. From the said bill, it would be evident that after 28.76 less, the final amount comes to rupees 91,89,936.29, and the agency was entitled to the amount for its work being NIT number such and such. Though the work was completed within stipulated time, that is important, stipulated time period, the respondent authority has paid a sum of rupees 71,97,000 only, out of bill amount rupees 91,84,936.29 only. The balance amount rupees 19,87,936 only, along with security deposit, is still due. Then Lordship, kindly have a look to page 46. Clause 3, the said work was physically completed on 15th of November 2017, and the defect liability period for this work being 3 years also completed on 15th of November 2020 as per terms of the agreement. The first and final bill of this work was submitted to BMS division in the month of February 2018 by the then assistant engineer, sub-divisional officer, duly recorded measurements, first and final bill drawn and duly certified in measurements book. Thereafter, an ad interim payment of 71 lakhs 97 out of the gross value of rupees 91,84,936 was made by BMS division in the month of March 2018. It appears from the submission of the parties in the said hearing and available office records, and the work order was issued in favor of the petitioner for the work, upkeeping and beautification works in connection with upkeeping and beautification of left bank of eastern drainage channel, Salt Lake City, at a tendered amount of rupees 77,311.17 only. And the work was completed within stipulated time period. The respondent authority has paid the sum of rupees 71,97,000 only. Accordingly, Special Engineer Salt Lake Reclamation and Development Circle was directed by board order sheet dated 23rd of August 24 to submit an explanation on the necessity of the additional work in question executed by the petitioner, and to confirm whether approval of this department was taken for the said additional work, as well as justification on the amount claimed by the petitioner for the said additional work. The required reply with technical analysis on the issue evolved here, along with supporting documents from relevant file records, was directed to be submitted within a week. Special Engineer Salt Lake Reclamation and Development Circle has submitted a report. The necessity of the additional work in question executed by the petitioner cannot be ascertained from the available office record files. Approval of the Urban Development and Municipal Affairs Department was not taken for the said additional work. Overall expenditure for the work was well within amount stated in the administrative approval and financial sanction, and it was completed on 15th of November 2017 prior to issuance of order number such and such. Now, my Lordship, kindly have a look to paragraph 6. Final excess savings and financial statement for the same work was recommended by the then executive engineer concerned, and the same was approved by the then special engineer concerned on dated 8th of March 2018, amounting rupees 91,84,936.29, which was beyond the tender value of the work 77,311.17. But within the administratively sanctioned amount, the executed work has been recorded in measurement books, and final bill has been prepared accordingly, duly certified by the then junior engineer, the then assistant engineer, and the executive engineer of BMS division. Now, my lord, next page 49, on examination of the submission of the petitioner, submission of the special Salt Lake Reclamation and Development Circle and their explanatory report dated 18th of September 2024, it may be stated that work order of the above mentioned work amounting rupees 77,311.17 was issued to the qualified agency, PAL agency, on 499 Damdam Kashipur Road. The concerned work agency submitted a proposal for supplementary tender for some additional works, and the same was approved by the then special engineer on dated 18/2000 18 amounting rupees 91 lakhs 84,936, which was beyond the tender value of work 77 lakhs 311.17, but within the sanctioned amount. There is no approval of state government in urban development and municipal affairs department for the additional work alleged to have been done. The petitioner in the communication bearing memo number such and such issued by Office of Executive Engineer, Bidhannagar Municipal Services Division, addressed to the petition, it has been stated inter alia that no excess or additional work should be taken up without prior written approval from the competent authority. The petitioner could not produce any document in support of the fact that such a prior written approval was given to the competent authority for the such additional work. The work order being such and such was issued for rupees 77 lakhs 311, but the payment has been made only for rupees 71 lakhs 97,000. Therefore, the balance amount of rupees 5 lakhs 3,311.17 be sanctioned the prayer of the petitioner to disburse the arrear amount for the alleged additional work for which there is no prior approval of the competent authority is considered and hereby rejected. My respectful Millard submission before your lordship is this, Millard. There was a post facto approval on the basis of the Millard issuance of second work order. I have completed the work. It is not my job to obtain an order for financial Millard approval, whether it has been approved by the state government or not. But why, Millard, my client will suffer? I have completed the work, and the reason order, Millard, it was specifically mentioned that with full satisfaction of the respondent authority, Millard, they have completed the work. And Millard, the 3 years, Millard, that period, Millard, that is, Millard, whether there is any damage, he will repair. And that period has already been, Millard, expired. Millard, my respectful submission is this, Millard, lordship kindly direct the respondent authority, Millard, to pay the balance amount.
Yes, sir.
In this matter, already I have contacted the concerned authority to comment on this license, but they have instructed me that 1 week's time to required to.
No, why? It's pending for long. You
2017 Millard work order.
come back on Thursday, day after tomorrow.
My lord.
I will not be here, but only
Friday?
Second.
Second, I cannot fix. I'll have to fix before 28th or on 28th.
I am not able to 7 to 31st. Second or third?
Second, third, I cannot fix.
Just have it,
I will not have determined.
Tomorrow, then, Millard, they will take instruction tomorrow. Let them take instruction, Millard, because I have served the copy, Millard, in the month of November to 24.
Come back tomorrow.
My lord.
Order record karen.
And let it be, Millard, give some priority, Millard, upgrade it, matter, maybe upgrade it.
The writ petitioner, affidavit of service filed today will keep the record. The writ petitioner seeks a direction on the respondent authorities to release a sum of rupees 19,87, একদম একদম যেরকম ছিল সেরকম না। আমরা চেঞ্জ অনেক কমে যাবে।
একচল্লিশ নম্বর আইটেমে অপোজিট এটা
কত নম্বর আইটেম?
41 41
এই নিন এইটা আপনি নেবেন তো এই যে